So let's settle a question that I hear way too often. If I get my kid a birthday gift, does that count towards child support? The short answer, no, absolutely not. Not in Texas, not ever, not even if it was a really expensive PlayStation. If you're confused about how this works, or if your ex is trying to act like the Christmas presents count towards child support, let me break this down for you. In Texas, gifts do not count as child support. It doesn't matter if you gave your kid a brand new iPhone, took them to Disney World, gifts are not child support. And the court still expects for your child support to be paid in full monthly. You may be wondering, why not? That's because child support isn't about extra, it's about covering the basics. Things such as food, shelter, clothing, things of that nature. Gifts, they are not regular and they are not tracked by the court. And most importantly, they don't keep the lights on. There are 6 ways to pay child support properly that are defined by the Texas Attorney General. The most common way is through a wage withholding order where your employer withholds the amount from each paycheck that correlates to the amount of child support that was ordered. The second option is to pay the Attorney General through their online portal directly each month when your child support is due. The third option is to have your child support paid through bank auto draft. The fourth option is through a money order. The fifth option is through the mail. And the sixth option is through a physical kiosk if you have one near you. If you are not using one of those options, then it's not being counted by the court and it will show that you are late on your child support, even if you have paid it. So don't pay them directly. So no, you can't hand your child $200 in cash and say, tell your mom this is part of child support for this month. That does not count. Sometimes people will say, well, we had an agreement. They said it was fine as long as I helped out with Christmas presents. That might be true, but unless there's a court order signed by a judge saying that that is okay, then it's not okay. Verbal deals don't override legal obligations. And guess what? If the other parent decides to take you to court for back child support, then you're on the hook for all of those direct payments that you made if they don't agree and sign an affidavit saying that you paid X amount on X day. Now, if you are falling behind on your child support due to a decrease in income or losing your job, then you do have the right to file for a modification. You can't retroactively change your child support just because you're falling behind on your legal obligation. But if your circumstances have changed because you lost your job or you recently had a pay cut, a judge can lower it moving forward. The worst thing you can do is just stop paying and you think that holiday gifts and school supplies will fill the gap. They won't, and it will come back to bite you eventually. So here's your takeaway. Gifts are nice, gifts are thoughtful, gifts are not child support. If you're under a court order, stick to it. And if you need to change it, file to modify it. And if you're confused, call us at Varghese Summersett. That's literally what we do.